Hi, my name's Lauren Graham, and I'm an intern here at National Right to Work Legal Defense Foundation.
And I'm Glenn Taubman, a staff attorney at the National Right to Work Foundation. And we're here to discuss the Dana case and another case called Lamons Gasket that is currently pending before the National Labor Relations Board.
Glenn, why don't you tell us a little bit about what is Dana?
Okay. Dana is a case dealing with card check recognition between the United Auto Workers and the Dana Corporation. These two parties entered into a collusive arrangement designed to grease the skids for employees of Dana to become unionized by the United Auto Workers. And one of the ways that this agreement worked was to not have secret ballot elections, but rather to allow these employees to be unionized via the abusive, coercive card check method, meaning that Dana provided the UAW with lists of employees, gave them access to employees in the workplace, allowed them to do home visits, and use other misrepresentations and harassment to get employees to sign union cards. Under the former National Labor Relations Board rule, employees subject to a card check had no right to call for their own secret ballot election to veto the arrangement that their employer and the union made. However, in the Dana case, litigated by attorneys from the National Right to Work Foundation, we were able to persuade the board in 2007 to allow employees to have a safety valve, a veto power over this collusive arrangement between the employer and the union to grease the skids for unionization.
Can you tell me a little bit about this 45-day safety valve that Dana has put in place?
Okay. Dana says that employees have a safety valve, have a veto power over these collusive card checks, and that employees, upon being notified that the employer recognized the UAW or some other union, employees have 45 days to file for a secret ballot election to veto the voluntary recognition of their employer. And this has worked wonderfully in quite a number of cases in which employees were able to vote out the unwanted union.
And this is all in jeopardy now because of Lamons Gasket. Will you tell us about that?
Right, correct. The Obama administration and its appointees to the National Labor Relations Board have the long knives out for the Dana ruling. They want to do away with secret ballot elections. They want only card checks, this abusive system in which employees can be coerced into unionization. And so they have accepted a United Steelworkers petition for review, with the issue being, should Dana be overruled? And they have thrown this open for public comment. Many unions have filed briefs in opposition to Dana, and the case is pending. But the bottom line is this. The Obama administration, having been unable to pass the so-called EFCA, the Employee Free Choice Act, is now trying to put all of this into play through administrative regulations and administrative decision-making. So again, it's the Obama administration and its appointees to the board with the long knives out to kill the Dana ruling, to kill employees' rights to demand a secret ballot election, and to put in place the abusive card check system instead of secret ballots.
Okay, so if we don't have the if we don't have the 45-day window, what happens then?
Well, what would happen if they overrule Dana and go back to the former rule? Once an employer recognizes a union, the employees are stuck for a minimum of 1 year, and in theory as much as 4 years, without ever being able to demand a secret ballot election. So if we go back to the former rule, there's no veto power by employees, there's no safety valve. The employer can make a collusive agreement with the union, can recognize a union, and the employees have no say whatsoever for anywhere from 1 to 4 years. And this is the true outrage of the system that the Obama administration wants to put into place.
Thank you so much, Glenn. For more information, please find us on nrtw.org.
Thank you.